Time is 8:48. I'm in front of the courthouse. It's the morning of 10:10. I have put together an information packet for the psychologist whom I will be seeing shortly, within an hour, and the packet is self-explanatory if you look at the cover sheet that I will be asking the forensic psychologist to sign. I'm doing so for her safety and her awareness in an assessment that she is making, as well as for my safety in being sure that she is informed with a degree of due diligence in her tasking to determine and make an assessment if I am competent in terms of understanding the object and nature of the court proceedings over a misdemeanor charge, which I am contesting and I wish to self-represent in. The reason I wish to self-represent is really quite clear if simply this documentation is read, because it shows that people have misrepresented me in the past, inclusive of people who are in positions similar to this lady's position. And so I want to be sure that she is aware that misconduct has already occurred stemming out of and from the federal government and the state of Maryland. And it is conduct that further has not been remedied in terms of the right to remedy when injury is apparent, inclusive of injury described in law as theft by extortion. Injury described in law as torture, and injury described in law as conspiracy against trade and imparting and conveying false information, denial of rights such as habeas corpus rights, when there's clear documentation that there's property that the government received and has not paid fair market value for. But it's a long story. This basically is just to make a documentation of the package of information that the forensic psychiatrist will be given. She told me to bring the information. I went early and saw her yesterday prior to this meeting to tell her that I had information for her, that I was clearly competent in terms of understanding the object and the nature of the court proceedings and dealing with this misdemeanor charge. But though it may be a misdemeanor charge, I am contesting it by right of law. I am asking for a jury by right of law. I am stating that I wish to self-represent by right of law and right of, a defendant is presumed competent in law unless there's reason to presume otherwise. And there is no reason to presume otherwise, since my actions have been totally coherent and legitimate all along. So the point is that though there's a misdemeanor trial, there's impeachment evidence, some of which this lady will be seeing, this doctor, in this information packet. And that impeachment evidence I intend to use in this misdemeanor trial because the relevant rules of relevant evidence say that I can. I also intend to use it in pretrial motions because there are pretrial defenses that say I can use such estoppel evidence under that type of rubric. So here we are, and I will be going in to see this lady in about 45 minutes. It's 8:54 now. My appointment's at 9:30.
Hello.
Hi, may I help you?
Yeah, is this 255?
Mm-hmm.
Because I've got this thing, and I was wondering, I'm supposed to meet a person. It says a judge here, and I was told it wasn't a judge, for a forensic appointment tomorrow morning at 9:30 a.m. And I was wondering who I'm supposed to be meeting. Sebastian?
Okay, yeah, I have you here for tomorrow at 9:30.
Okay, so may I borrow a pen real quick?
Mm-hmm.
And who am I? I'm sorry. Your name is?
Dr. Roy.
Dr. Roy. Hello, Dr. Roy.
Hi.
Are you the person I'd be meeting?
Mm-hmm.
Okay. Well, Dr. Roy, how do you spell your name?
R-O-H.
R-O-H.
R-E-R.
R-E-R.
Mm-hmm.
And you're the forensic psychiatrist?
Psychologist.
Forensic psychologist.
Mm-hmm.
Okay, well, it's a pleasure meeting you.
Nice to meet you, too.
And I look forward to seeing you tomorrow.
Mm-hmm.
Now, if I may, run some information by you really quickly.
Well, if it's about your case, I can't talk to you about that.
It's not about the
Okay.
case. It's about your mandate, really, which is, from what I understand from doing my legal research in aiding my defense, is, and also showing that I understand the object and nature of the court proceedings, is to be sure that this is what you're about, because if I'm sent to see you and you're not my doctor and I have medical privacy rights, but I'm going to court over a misdemeanor and I have a defense that I would like to implement, but through self-representation, I wanted to be sure that we are of the same page in terms of what your mandate is, what it is that you're looking for. If there are any questions that you'd like to have me give me in writing that I might be able to respond, that would meet my obligations to prove to the court. And mind you, the court has a presumption of innocence. The defendant is presumed innocent and competent. Okay? So if there's a presumption of competence, and I'm supposed to be discussing this with you, is there a set list of questions that you would be asking? May I see those questions so I might answer them
about all this
or do
tomorrow.
the research? Okay. Well, if that's the case, and you're also in an investigative position,
No, I'm not an investigative position.
well, if you're investigating my competence
It's an
to
assessment.
stand court, that's an assessment, and it's an investigation, and you're duty bound by the medical ethics rules, which I have, and
I'm not a medical doctor, I'm a
no,
psychologist.
I know, but you're also a forensic psychologist, which I would imagine would mean also that you're a legal lawyer. Is that correct?
No, I'm not a lawyer.
So you're not a lawyer, you're just a psychologist, and not a psychiatrist.
Correct.
So you're not a medical doctor.
Correct.
All right. So in your, and I'm just
I need
trying.
to get back to work, but
Okay.
we can discuss all of this
Well,
tomorrow.
I'm going to bring you information
Okay.
dealing with the circumstances surrounding the instant allegations.
Okay.
And dealing with an estoppel defense. Do you know what an estoppel defense
We'll
is?
discuss, I need to get back to work.
Okay,
We'll
good.
discuss all of this
All
tomorrow.
right, well, I will be bringing you information, and I would like you to sign it, that you have seen it, and that you have read it, and that
Well,
you've done
I
your
need to
due
see what it is
diligence.
first.
That's fine. But I will be expecting you to sign it, because if you're doing this effort, then I'll be able to bring you everything that you need to assess the material. I do have a reasoning IQ in the 99 percentile, and that's been documented by Harvard psychiatrists.
Okay.
And I've also got other psychiatrists who have said that I have no delusions, that I'm competent to contract.
Okay.
And this whole kind of situation has happened before.
Let me know tomorrow.
Well, I thought that you'd like to know now because
Well,
I
I'm
wanted.
working on some other things right
Okay.
now.
Well, I will be bringing you, if you'd like, for preparation, so you can make your report in a
Sarah, I'll
timely
see you
fashion.
tomorrow at 9:30,
Okay,
okay?
I can bring you information now. I can print it out of the van if you'd like.
I'm busy right now.
Okay.
You can come back tomorrow at 9:30.
Well, anyway, it was a pleasure meeting you.
Nice to meet you
And I'm
too. I'll
sorry
see
to
you
meet you
tomorrow.
in this somewhat adversarial situation. But this is court, and it's an adversarial situation. And I've been in a nightmare before that I don't want to repeat. So anyway, I'm charmed, my dear.
See you tomorrow.
And I look forward to
I'm
it.
glad you found the office.
Well, I
See
wanted
you
to be
tomorrow.
sure that I was prepared so I could aid in my defense and show you that I know the object and nature of the court
I can already
proceedings.
tell that you've done your research.
Thank you, my dear.
To wet my whistle.
So before we discuss this, I need you to because this is a forensic evaluation, as you know, nothing is confidential. So anything we talk about or that you do in this context, I can report back to the judge, the attorney, the prosecution.
That's why I gave you that form to sign. Basically, it's just giving you due diligence information for your assessment. And it's for making sure that everything is assessed correctly. Right there, the first letter that you just finished looking at says that I've always been competent to contract and that there's intellectual property that should be adjudicated by civil and criminal state and federal courts. That was never adjudicated. You'll also see motions to suppress evidence prior to adjudication where they say that information, intellectual property, went to government. That right there says that I have no delusions and have no need for medication.
Well, Mr. President,
You'll also
stop
see
you
stuff
right
that
there.
says that I've
This
got
is right there.
99% reasoning IQ, and if reasonable man has any bearing in law, and it does, what a reasonable man would do, then
These are
I'm...
back from 2006, 2007.
That's correct, but none of that has been adjudicated, and it's called the continuing criminal enterprise. Right there, you're looking at information on the object and nature of the court proceedings law, detailing such. There, you're looking at the denial of a habeas
Well, right,
corpus.
but you've done research on competency, right? So you know competency is about current mental
Correct,
status.
correct. It's about the current trial, which is over a
Well,
misdemeanor,
it's also about your
but
current
I
mental status. And so
my current
these
mental
records from
status
2005, 2006.
show that my mental status was fine then, and in law,
Well, that was
your
22 years
defendant is presumed competent.
Okay, well,
Now, you know, you have to find cause to say that I'm not competent if you do
Right.
decide to say that I'm not competent. Okay, so you've looked over that packet. I will leave it with you. I would like you to sign that you've looked it over. It's for your protection as well as mine. And it's simply for, as you said, to enter that information into court because there is no rights that I'm accorded if I communicate with you other than what we're doing right now, I guess, you know. I'm
Well, you
assuming
have
I will
rights.
be signing something. Well, you're going to
you
be...
will not be signing anything for me.
Okay, so you've informed me of any
nature.
communications that I make to you will be used in your, could be used in your assessment for the judge for the current misdemeanor charges.
Correct.
Okay, and I am saying I've shown you this evidence because there's impeachment evidence in there for this misdemeanor trial. And if you look at the rules of evidence, you will see that there's impeachment evidence if you look at the material in depth that I've left you. It's also evidence that can be used in pretrial defense motions, such as an estoppel defense motion. I don't know if you know what an estoppel defense motion is.
Your understanding of it.
Okay. Well, I can direct you to Black's Law Dictionary. It would give you a much clearer picture. But if you're asking me my understanding in general terms, as a layperson, because I'm not a lawyer, it is a pretrial motion that you put in. It's an estoppel motion that says that the party that is bringing charges, or their claims, if you will, should be stopped because it did not perform in prior duties which made the current situation a situation of inequitable balance. In other words, that I, as a defendant, asking for a estoppel pretrial motion, which can also be denied by the judge, but the same evidence I'm using for estoppel, I will be using for impeachment. So it's really one or the other. If you look at the relevant rules of evidence for introduction of evidence into this misdemeanor case that we're talking about for impeachment purposes. But the estoppel part is where, because of government's failure to do its duty in a prior situation, the circumstances surrounding the instant allegations of this misdemeanor charge, I'm at a disadvantage in my ability to protect my rights and my interests. If you look at the theft by extortion law that is right here, you will see, indeed, that all the criteria in this instance are also met by theft by extortion, because you're talking about...
We only have an hour.
All right.
Well, and there's certain questions I have to
Okay, well, I was trying to answer your estoppel questions in relative detail.
Well, I just needed, a brief what your understanding
May I get you to sign?
I am not going to sign that because it says things that I don't know if that's going to be accurate.
My name is Dr.
I read it.
It's on videotape, it's on Facebook. It should be totally innocuous. As I said, it's for your protection and mine, because you're reading stuff that also...
This is not a legal document. I'm not going to sign it because, because the last thing says...
Witnessed by me.
No.
You sign it.
Information will be noted in my assessment. I determine what's
okay, well then we can change that and sign it out, and I can say may be noted.
I'm not going to sign it.
It's a legal contract, or it's a legal attestation, if you will, if you sign it and I sign it. Just like, all right, well, you don't have to sign it. As I said, I put it on Facebook. You told me to bring this information. You said that you will review it. Am I correct?
Mm-hmm.
Okay, so we're great.
What's your date of birth?
11/12/57. I may decide that I don't want to answer questions because I also have a right to protect myself.
You have the right to not even participate in this evaluation.
Well, you didn't tell me that beforehand, because if you had told me that beforehand, I wouldn't have gone this far at all. I would have just dropped off the information for you and left it at the rule of law says that I'm presumed competent. Mm-hmm. Is that not correct?
That is the law.
Okay, good. So if I'm presumed competent, and I put together a package of information to protect my competency in your report for the court, where the competency is at question, that should show that I've aided in my defense, especially if I put together a package of information, as you see, dealing with the law over competency. In other words, the ability to understand the object and nature of the court proceedings, and to be able to aid in my defense. Just this packet alone should be able to show you that I can aid in my defense. And as far as understanding the object and nature of the court proceedings, I can describe to you all of that. And I've already done so in multiple places, which are online.
Okay, I
So,
need to interrupt you. I put those questions again that the
all right.
judge
Well,
needs answered.
Well, the judge needs answered, or you're going to have to answer depending on
The judge
my
has
presumption
certain
of competence.
And so I needed to start with demographic information.
Well, I will stop if and where I feel the need
How
to
old
stop.
are you?
I'm 57,
Okay. What's your social security number?
218. Now, mind you, I might have to add, I've tried not to pay attention to how old I am. Nobody's really celebrated my birthday in a while. But I'm right in there,
Where
you
were
know.
you born? What city?
I was born in Rockledge, Florida.
Is that 2 words?
Rockledge is one word.
L-I-D-G?
L-E, Ledge,
Ledge.
Florida.
Where's that near?
It's right near Cocoa Beach.
Oh, okay. And,
Sister city to Cocoa Beach, in fact. My grandmother helped found Rockledge.
okay. Well, who do you live with right now?
I live in a house by myself. I had some fish in a pond in the backyard last winter. Something ate them.
What's your phone number?
My cell phone number is 301-704-2662.
And are you working right now?
I work doing legal rights work in terms of, I used to have a graphics and printing company, and as you can see, you have a package of graphics and printing dealing with legal rights. So my work is to get to my intellectual property and not be further savaged through human trafficking and theft by extortion, which is provable, and other legal minds have said so.
Okay. How far did you go in school?
I've got a double major in international relations and language and foreign area studies from American University.
I'm sorry, international what?
Relations and language and foreign area studies. I also have taught, so you can say that I went to school, martial arts, and I have run printing companies by learning about printing and taking printing classes. I have one test shy of finishing a paralegal certificate at Georgetown University, wherein I aced the litigation classes.
Okay.
Is that good enough? I could
Yeah,
continue.
that's fine. Ever been married?
Never been married.
Do you have a bachelor's?
Yes, a bachelor's,
Okay.
double major.
Any medical or physical problems?
Other than the tooth of time and not being able to go see doctors until my rights have been adjudicated, because people tried to poison me, as you will see in this information, where, well, you won't see it in this packet, I didn't bless you with that, but you will see where people tried to poison me, and then they discovered that there were no delusions. Mind you, this was over intellectual property that had not been investigated, though I gave people investigation material. And it says so in a motion to suppress evidence. The government received property and never investigated, but they seemed to feel that they could all of a sudden call me delusional. And
Who called you delusional?
well, the state of Maryland tried to call me delusional. You will see from this packet that the state of Maryland recanted from their assessment of delusions and recanted from their forced injections, but never investigated the false information that was entered into court by people who hold similar positions as you, my dear, in Maryland, excepting that they were more hybrid. You are not a lawyer, you are a psychologist, and you are not a medical doctor. They were psychologists / lawyers. So they had fiduciary duties that they breached more egregiously than might be otherwise.
Okay. You taking any medications now?
No, ma'am.
You have in the past though, right?
No,
You mentioned
ma'am.
injections.
Those were forced injections done criminally, and there was a judge's order to stop the criminal forced injection.
What was in the injection?
Well, I don't know what you call them, whatever drugs, for psychotic type thing. But you need to put in your notes that it was done illegally and stop. Indeed, there are documents that I will send you now through FedEx and have them downloaded that show that such injections and medication and all that was done illegally. Indeed, you have a medical medical report signed statement by a doctor saying that there was no need for medication and there are no delusions. That was the final assessment, so that we are very clear. And mind you, they're also the same doctors that said intellectual property needed to be adjudicated. And it's intellectual property that is date and time stamped. You will see, for instance, a provisional patent that was, all right. I've been known to have a good here and there.
Any drug use?
I've been known to use drugs in the past. There's been no drug record since 1986, no drug arrest since 1986.
Do you have a history of being arrested for drugs?
I don't know what you would call a history for being arrested with drugs. There's a record of drug use. It's in the charging documents. If you care to do your due diligence there, you'll have all the information that you need.
Okay. Well, I'm asking you. So you haven't done any drugs since 1986, is that correct? Or there's just documented?
I'm telling you about what you need to know for your assessment of my competence. I'm not telling you anything more than you need to know for your assessment of my competence.
Okay, well, I determine what I need to know.
All right, well then I will stop the conversation here. Now, if you figure that that's what you need to pursue, because I don't need to volunteer information, and I don't need to have to plead the fifth when I'm trying to aid you in your assessment so that I can be found competent to stand trial on a misdemeanor charge. I don't know too many people who want to be found competent when they are charged with criminal behavior. So let me just say that I've delivered you everything that you need in my estimation. And if there are any other questions that you would like to ask me, feel free to ask, but we will bypass that question, despite the fact that it may be in your paradigm where you have to have that question answered to make
I
a
would like to have an
determination.
answer, yes.
Well, you may like to have an answer, we will stop the discussion now.
That is completely up to you.
Well,
I'm going to continue
So,
your question.
well then, you can continue the question, at least so long as we bypass that question. I told you I'm not answering to that question.
Ever been in rehab or substance use treatment?
Many, many years ago, around the time of the charging documents where it says that I had a drug history in the past. You do your due diligence.
What are you being charged with now?
Mind you, when you asked about drugs, I do
Excuse
consider
me.
alcohol to be a drug.
Okay.
So we're very clear. It's on the
Please don't
napkin.
touch my sock.
I was just holding the piece of paper.
Okay.
For a
What are you
second.
being charged with?
I'm being charged with a misdemeanor charge that is
What are you charged
you can look that up if you want to do your due diligence on the charging document. I'm telling you where you can get that
with?
information.
Okay. Sir, you've read the competency statute. You know that one of the things about competency is knowing what you're being charged with.
Yes, and I've
So
told you what I'm being charged
specifically,
with.
I'm asking you what substance.
Well, I'm telling you that I know what the charge is. I don't want to verbalize it. But if you want to know that I know what the charge is, it's on the charging document.
Well, that doesn't give me evidence that you know what.
Well, let me provide you with the charging document then, and you can read it yourself. How's that?
I have it.
Well, if you have the charging document, and you can read English,
Okay,
and
sir.
I've given you
This is
stuff
what
in
I-
English.
This is over.
All right.
Okay, thank you.
Thank you.
Have a good day.
And you. My dear, I told the judge in court that I would be taking this information, this hearing. So be aware.
So, this is the forensic psychologist, not psychiatrist, not a medical doctor's report. And you will note that she's lying. She's lying in a number of places, dealing with language, with coherence, with any number of things. She mentions the documents she got, but she says they're dubious. She mentions something, well, maybe should be authenticated, but she's slandering so much that it's just like a byline. Now, you authenticate the documents, those dubious documents, and you will see everything I've said is absolutely correct. So, here we have obvious lies because they conflict with the tape. We've got little bits of truth weaved into a massive slander by a woman who wouldn't sign for documentation and uses such documentation to further her story in slander, and then says offhand, well, you know, dubious, maybe authentication, just to try and cover her butt. Because, as I said, some of those documents have a prior state's attorney's signature on there saying that other documents are accurate, and then there are other documents that have other people's signatures on there saying there's property, there are laws saying property is supposed to be adjudicated, other people saying that government failed to investigate, and so this utter piece of slander is the exact similar stuff to other people in this woman's position who have done this in prior instances, where it turned around after 2.5 years and people decided, oh, well, yeah, maybe it was slander because I was seized illegally, because nobody investigated intellectual property and the circumstances surrounding the events of all that slander and those allegations, but nobody wants to authenticate anything. Well, this woman says authenticate, and she mentions documents. It's about that easy to authenticate the documents, and then if you put everything else that she wrote, you know, and the way I presented myself and so on, seems to me I was seamless. And she was the one that threw the temper tantrum, and she was the one that asked the questions that she used that I didn't even really have to answer. I should have just popped the documents down and insisted that she sign on it, and if she didn't, then leave. But now we have a judge who also did not look at 42 pages, a lot more than this woman got, of evidence to support my claims, to contest the allegations of not competent. You know, if I came up with all that property, intellectually speaking, and other people are validating, there had to have been some competence someplace. Fact is, they're even saying it was totally competent 2007, and my claims haven't changed at all. I'm just entering it as legal evidence to contest again, because if you recall when they dropped the last charges, it wasn't just threatening people, though they admitted the law, using the law, but they tried to do false trumped drug charges. And if you note the paperwork from before, they couldn't even figure out among themselves where they found the drugs. Well, it's kind of the same thing in this situation. And it can be blown out of the water so long as I'm allowed to show that it was all a setup. And I said so from the beginning, the day before I was supposed to go show posters on the river. That's right. And the witness can testify that there's a whole lot more that was said and that wasn't said, but they said was on the charging documents. Let's see them get their stories straight again with so many lies. They can't. They would have to drop the charges, every which way, and they're struggling mightily just to disappear the Constitution and do massive theft in intellectual property while harming and damaging everybody's rights in most egregious and injurious fashion. That is what you see there. Here is what you see. It's called theft by extortion, and it is a count, and it is evidenced, and we have this woman's signature right there. And we have a judge that's tried to go along with it and made an order that I don't have to obey because I said I objected, and I don't have to obey to coercion when she has to do her homework and authenticate those documents. This woman is saying could be authenticated. You know, maybe, I mean, it's dubious, but maybe it ought to be authenticated. Well, let her authenticate, and then she won't have to send people after me to attack me and injure me because I won't be out of compliance, then will I? Well, I got a stack of stuff. In triplicate. Printing out the stuff dealing with Hunter. For informational for the judge. So the printer is working beautifully. I'm gonna put in more paper. There. So the printer is working beautifully. Here we have letters to Emden, to Hunter, and informational for the judge stuff. 20-odd pages. Certificate. We have tons of stuff for the judge. Tons of stuff for the judge. Tons and tons and tons of stuff. It'll all be stamped, my copy. And this is the last of the stuff I'm printing out because it's 3:57 now. And gotta go to the courthouse over there in just a little bit before 5.